afternoon and welcome to today's presentation on what issuers of municipal bonds and their officials need to know after MCDC and the City of Miami. My name is Jonathan Frels. I'm a partner at Bracewell in their Houston office. I'm going to be moderating today's panel. With me, I have Paul Maco and Barron Wallace. Barron is also a partner in our Houston office, and he's the head of our public finance group. Barron's practice focuses primarily on municipal finance transactions, both as issuers counsel, underwriters counsel, and bond counsel, as well as disclosure counsel, and then also on urban development issues. Paul is a partner in our Washington office, and he's a former senior official in the United States Securities and Exchange Commission. In that role, he was the first head of the Office of Municipal Securities for the SEC. Today, Paul provides clients, including issuers, broker-dealers, and municipal advisors with comprehensive representation regarding enforcement, regulatory, and compliance matters in front of groups including the SEC, Department of Justice, FINRA, and the MSRB. Now, for state and local governmental issuers and others who issue municipal bonds, it makes a lot of sense to follow what the regulators are saying about the municipal market. And today, we wanted to dive a little bit deeper into some of the recent issues that the SEC has been focusing on. We're going to discuss what recent signals they've been providing to the market, what's behind the signals that the SEC is providing to the market, and how best to respond to those signals. So Paul, the municipal market right now is in a period of very active enforcement. This has manifested itself in a string of comments from SEC officials and commissioners, a slew of enforcement actions, and then also the MCDC program. What kind of perspective can you give us on what has led to this round of enforcement activities?
Jonathan, the Commission's laid it out quite clearly. Just a few weeks ago, right after announcing that she would retire the day of the inauguration, SEC Chair Mary Jo White gave a speech looking back to the time that she first went through her confirmation hearing. 3 weeks ago, she said that the SEC had, by design, brought all the enforcement tools to bear in the municipal market. About that same time, some years ago, actually in February of 2013 at the Bond Buyer Conference in Austin, the then head of the Fort Worth office, David Woodcock, gave a speech in which he said the SEC was now investigating to litigate. They weren't investigating to settle from the get-go in an enforcement investigation. They were investigating to litigate. Chair White had highlighted that in her speech and also noted that she had pledged during her confirmation hearing that she and her commission would have a bold and unrelenting enforcement agenda. She, in her speech again 3 weeks ago, she summarized what she's done over that time, addressing particularly the municipal market. She said that the Commission had identified a critically important area where they've brought to bear their bolder and more unrelenting approach to enforcement to change industry behavior. So that's really that's the mindset that's behind the chairman setting policy and directing enforcement policy. The Commission had already been moving in an informal way of naming individuals along with issuers or firms in enforcement actions on the basis that companies or municipalities don't commit disclosure fraud. Individuals do that. Individuals at the company or at the municipality are the ones who should be sanctioned along with the entity if any kind of behavior was going to be changed.
So Paul, with that background, can you talk to us a little bit about what the SEC is saying to us, both in terms of the cases that they've chosen to bring, and then also the manner in which they're bringing those actions?
Well, they're trying to make it very clear that while they don't have the regulatory tools that they have in the corporate area, They are going to devote their enforcement abilities to correcting the market, to making sure that investors have information that's accurate and reliable. They are really tapping into every tool that they have, and they've used industry bars, as we'll see. They're bringing penalties against individuals. They are using the control person liability theory, which they used against two mayors who never laid eyes on a disclosure document, but nonetheless were aware of what was going on and therefore were considered to be in control of the issuer. So there's quite a bit going on, and in a number of their recent cases, you really see it playing out.
Are there any particular enforcement actions that you'd like to call everybody's attention to on those?
So a couple that I think are worth highlighting that have occurred within the last year and a half. I think everyone is familiar with the City of Miami case and the SEC's trial against both the city and its former budget director, Michael Boudreaux. That's really worth pausing and taking a good look at. The city, of course, had been in previous litigation with the SEC back in 1999 through 2003, culminating in it started with an administrative proceeding, litigated, went to appeal to the commission, and full hearing before the commission. The commission, after a full retrial before the commission sitting as an adjudicatory body, issued a cease and desist order, finding that the city had engaged in accounting fraud. Time passed, 2009, financial crisis. Housing revenues, taxes, property taxes coming into the city take a real dive because of the real property valuation dive. The city's struggling with its budget. City has some internal problems with its internal controls, and all of which came out at trial, but puts information in its CAFR, just moves money around from special dedicated funds into the general fund, back out again, discloses it all in its CAFR, but mischaracterizes the status of some of the funds, and on that basis, the SEC brings a fraud action for 3 different official statements issued by the city during that time, plus the CAFRs. Along with that is violation of the cease and desist order. Back and forth between the city and the SEC over a period of time, and this past September, the whole matter goes to trial. 2 weeks at the trial, after putting in evidence from all different sides, the judge sends it to the jury. After 4.5 hours, the jury comes back, finding against the city and against the city budget director. SEC then moves to the penalty phase. City negotiates the penalty settlement at $1 million fine for the city, nothing else involved. Boudreaux says he's going to appeal and indicates, so he's not going to settle with the city. The city nonetheless proceeds to file with the judge seeking $450,000 in personal fine from the former budget director, and files with it an extensive brief arguing why this individual should be sanctioned with such a heavy penalty. 2 days ago, the judge comes back, issues her ruling on the remedy, rejects the SEC's call for drastic remedies, puts in a $15,000 fine, refuses to issue an injunction. So, and in her order, which is about 20 pages long, goes through a very detailed contrast to a typical corporate official who has been the subject of SEC enforcement proceedings to the municipal official involved. That's one.
So Paul, with that one, you again are seeing a focus on an individual that's there. In the Westlands Water District case, the SEC also focused pretty extensively on individuals as well, correct?
They did, and that was an accounting case where the district appeared to be in violation of its debt service coverage covenant and outstanding bonds. Talked with their accountants, and the accountant said, well, you can engage in this particular type of transfer and adjust your balance sheets, and it will it'll all be fine, and you won't be in violation of your debt service coverage covenant. This is all explained at a meeting where one of them, unfortunately, and on videotape, says to the council, well, this is just a little Enron style accounting maneuver that we're going to engage into. Of course, the SEC picked up on that, as they would, but the net result is that even though the accountants had signed off on the financial reporting, the purpose of the transaction was intended to basically mislead investors. The SEC aggressively pursued that action. The two individuals, the general manager was subject to a $50,000 fine personally, the deputy general manager $25,000 fine, the issuer itself $125,000 fine. Along with that, this past spring, the SEC and the Department of Justice took action against a town in the northeastern part of the United States, along with its local development corporation. Really, the way to grasp the context of this dual enforcement matter is to just understand the way it all unfolded for the public. Early one morning, the town supervisor heard a knock on his door, opened the door, and there were several agents of the FBI arresting him. They take him in, bring him in for an arraignment. At the same time, the same thing's happening to the former executive director of the local development corporation. Goes in for the arraignment. A few hours later, Preet Baraha, the U.S. Attorney for the Southern District of New York, who we normally see at press conferences and some large insider trading investigation or some anti-terrorism investigation, is announcing the indictment of the town supervisor and the executive director of the local development corporation, while at the same time the SEC is filing charges in federal district court of a civil nature for securities fraud against the town, the local LDC, the town supervisor, the town attorney, and the town deputy finance manager. You can see that they are coming down, as Chairman White said she would 3 years ago, as hard as they possibly can on issuers and issuer officials in the municipal community. They're not sparing any, not pulling any punches. They're coming down as hard as they can. So it is definitely a different climate.
So Paul, in the midst of this string of enforcement actions that you're talking about and this aggressive focus on individuals, this is all happening in the midst of the MCDC program. Can you give us an update on where that stands and what we can expect to see out of that going forward?
I think that we're waiting to see if there are any additional actions that will come of it. We had a somewhat cryptic statement from Leanne Gaunt, who has said that they haven't wrapped it all up. They intend to let everyone know who submitted, the status of their submission. That is, they can expect to either hear something from the division in terms of a settlement offer or in terms of a notice of closing the investigation. Now, that having been said, in the speech that I was referring to November 13th that the chairman gave, all of her language seems to sound as if the matter has essentially been wrapped up. If you look at the symmetry of it, there were 72 actions in total when you include Kings Canyon Ranch against issuers. There's 72 actions against municipal underwriters. You've got just about every type of issuer in the United States. A few states, a few authorities. You have a charter school, fire districts in the middle of North Dakota. I mean, you just pick the variety, and they're all in there, along with an incredibly detailed description of what the Commission believes to be fraudulent descriptions of continuing disclosure compliance or absence of descriptions of continuing disclosure non-compliance. So they have this one package, and it's not surprising to see that just a day or so ago, one of the congresswomen released a draft of a bill that would give legislative authority to the SEC to require the filing, the registration of municipal issuers, remove the exemption for conduit financings, that is industrial development bonds, and give the SEC authority to set disclosure requirements in a series of areas, all of which tracks almost to the item the materials laid out in the wish list, really, in the Commission's 2012 report on the municipal securities market. So to one degree, they have the centerpiece that they need to go forward with legislation in Congress, but they also have a very detailed set of descriptions of what they consider to be the wrong way to do it in describing compliance with continuing disclosure undertakings.
So Barron, as we're turning back to these recent issuer settlements under the MCDC program, as you know, there's significant discussion on all the transactions we're involved in about what's appropriate to disclose in an official statement regarding compliance with prior undertakings. What are some of the general themes that you saw highlighted as you look through some of the MCDC settlements?
Well, you know, Jonathan, we'll go through the general themes, but I think it's important just to take a step back and understand, you know, how did MCDC come about, and really, you know, what 15C212, Rule 15C212 requires, because that's really the basis of it. I think we all, in our practice, deal with that, but I think MCDC has brought a different light to it. So we all know that under 15C212, the underwriter has to ensure that there's an undertaking between the issuer that covenants that they're going to provide annual financial and operating data, and also provide events, 14 events annually to the extent that they occur. But also importantly, it requires that the official statement provide any material instances where you have not complied with the undertaking. And I think over the last 4 years, there's been a lot of confusion about that. There's been a lot of issues where the market over, say, the past 20 years, since 1995, evolved to the point to where we would all make statements that we have materially complied, an affirmative statement. And I think what we learned at MCDC that potentially, and you'll certainly learn as we go through the settlement orders, is that that statement, the affirmative statement that you have complied, was the basis of most of the material misstatement claims that the SEC brought about. But what we also found of what is material non-compliance. And that, I think, is one of the important things that, you know, whether it's better or worse, at least we know what the SEC is thinking. But, you know, look, what are some of the big takeaways? That clearly simple misrepresentations, and I say simple, but one misrepresentation in your official statement where you may have not filed or properly cross-referenced an item, and you don't note that as a material non-compliance, is something that could be a problem for the SEC. Clearly that's an issue. Failure to timely file required notices of late filings. So not only were you late, but not telling people through another notice that you are late could be a problem. While we don't know specifically what is too late, we do know that if you were 36 days late, that period of time under the SEC would seem to be material and not compliant with your undertaking. Failure to file notices of redemption and notices of defeasances in a timely fashion. I was remarking to Jonathan and Paul earlier, I know that there was a time when we were do deals that would be sort of the last thing you would do, you would remember to do. But in many instances, the SEC noted that not filing notices of defeasance, and frankly, there's a question of not filing them at the point when the issuer has made a determination to defease could be a problem. Instances of not having the CUSIP numbers properly coded or properly identified with the issue is also potentially a problem. So we've seen a lot of fact situations that I think in general over the last 2 years we've opted to disclose those issues.
Mm-hmm.
As our partner Glenn Opal, who was going to join us but couldn't make it, he goes, it's a race to the bottom, that you just disclose everything that you possibly can and then no one can criticize you. But in a way, the SEC has validated that approach, that it makes sense just to mention it all and not try to determine materiality, because in some fact scenario, you may be able to get there.
Yeah, I think that's the thing that stood out most to me was how aggressively they were stating what is material with respect to non-compliance. A couple of them that really stood out. One of them was cross-references. So in a number of instances, you saw issuers who had filed official statements as a way of talking to the market about filings of financial statements and other issues. But the SEC came back and said, where there's not appropriate cross-references, in order to demonstrate that official statement was filed for that particular purpose, that it may not be sufficient in order to achieve that. That was something that really stood out to me in this process.
You know, and I think part of that, and I think if you look at the NABL guidance that came out in the midst of the MCDC program, the summer just before underwriters were required to file, and with the extension just about 5 months before issuers needed to file. The consensus group that put together the NABL guidance took a similar approach. They thought that the term material would really be a significant separator in the actions that the Commission decided to pursue in the cease and desist orders against. But it didn't work out that way. When you go through these, it's very granular, as both Barron and Jonathan have indicated. The cross-reference part is something that the SEC made very clear in the adopting release and follow-up discussions, that you had to clearly cross-reference where it was on EMMA. But the feeling among many in the bar was that, well, if the information's there, it's out in the total mix of information, investors can access it, or if it's on their website, they're certainly not they're not hiding it, they're not attempting to do anything nefarious or to mislead the market. How could that possibly be material? But again, unchecked by the push-pull of full investigation, you have the SEC Enforcement Division sending these things up to the Commission, and the orders coming back, laying out what we really now have pretty much to live with, it would seem, as their lines of what needs to be included in discussions of disclosure non-compliance.
Another one that stood out to me, and I'd like to get y'all's comments on this too, is that there were a number of settlements that mentioned people's failure to comply with their continuing disclosure requirements prior to entering into a new offering. Can you talk to us a little bit about where the SEC was coming on those?
What they were doing, at least as I read those, is pointing out that you're going to market and you're saying, this comes back to that statement, we've complied in all material respects. I'll come back to that in a minute. But instances where that statement was made, and yet within a brief period of time before the bonds were issued and that statement was made, the issuer was in a state of non-compliance with its undertakings because they had things that should have been filed that weren't filed at that point. One thing I'd like to just note about that statement, that the issuer is in compliance with all its prior undertakings. There's nothing in the rule that requires that. Back in 1995, when people first started complying with 15C212 and filing, or the undertakings and filing these statements, I was at the commission at that time, and we saw these official statements being issued with that statement in it. And why are they saying that? There's nothing in the rule that was intended to require them to say that. But it quickly became industry practice. And the result of that is really sort of a setup. It really puts the bar out there for the issuer and sets them up for a potential easy failure if they've missed something somewhere along the line. The other important thing to keep in mind in analyzing compliance with undertakings and disclosure in official statements is a very simple dichotomy. Compliance or non-compliance with an undertaking is a matter of contract law. If you don't comply with the undertaking, there's no violation of federal securities law. The contract may have been breached, but there's no violation of federal securities law. So there's nothing really there, certainly, to be embarrassed about. Disclosing it shouldn't be a problem. You're not disclosing some deep, dark secret. You're not admitting to a violation of federal securities law. Where the violation of federal securities law occurs is when the bonds are issued with an offering document that doesn't disclose adequately, as the commission has indicated, prior non-compliance with continuing disclosure agreements. The focal point for securities fraud is in that description that's in the offering document, not with any past actions with respect to the continuing disclosure agreement. And that's really that's critical to understanding where the SEC is coming from, where the penalties originate, and hopefully will make it a lot easier for issuers and officials to come to terms with their whatever non-compliance might exist.
And Paul, I don't know if we can say all 71 or 72 settlement orders said that, but I would say a fair majority of them, large majority of them, the issuer did state that they were in compliance with all of its all material respects with their undertaking. And in each one of the settlement orders, the SEC noted that that was sort of the point where they committed fraud under the SEC.
Yeah, and I think you're really starting to see a change in the market here recently on that. I've seen a number of issuers who have asked to take that language out of the documents and just have a statement on areas where they may have failed to comply in some respect with their undertakings. And then underwriters asking, instead of having it in the offering document, to instead include it in the BPA, a statement that, except as described in the official statement, that you had complied, so that it shows up there. So that's one market change that I've recently seen.
And we've seen that, but at the same time, that can still give risk to an issuer if it's not correct. I mean, the only way to really correct it is to have appropriate diligence on the underwriter side, on the issuer side, and really a conversation about what the issues are, and then describe them appropriately in the offering document. I mean, that's what I would think would be the way to do it.
I think it's important to note on the bond purchase agreement example, that still involves a statement that's made in connection with the offer and sale of a security. And so it doesn't move it just moves it to a different document or a different place, but there's still a potentially misleading statement if the official statement doesn't end up containing all of the descriptive language about prior non-compliance that it should. You've just moved it from one place to the other.
And I think that's a really critical point as you see the market move and people are working on that shift, because there's also some risk to underwriters as well in having those statements in those two documents. And so I think we're going to continue to see that evolve over time. I think it's a conversation that everyone's.
Yeah, we're not trying. I don't think we're solving that right now, because I think we all understand that we represent both issuers and underwriters at different times, and underwriters obviously need to be able to have some confidence or information that they can check on them and they can get DAC reports. But ultimately, it's the issuer's responsibility to know what they filed, and that is important for them to be able to say. And if they can't say it, well, then why?
So, Paul and Barron, as you look at these settlements, are there any other issues you think that the group really should know about from a standpoint of where the SEC has found something to be material?
I just want to make sure that we note this, and I'll give some names, so in case you ever want to go back to the Ascension Health Alliance, which is in Missouri, that's one where the SEC's, where they made the statement that they never failed to comply in all material respects with any previous undertaking, but the SEC order stated that it was false because the issuer failed to file notices of defeasance prior to the offering, though due before. And I want to be able to be clear about that. We're not exactly sure what the SEC meant when they said they didn't file before, though due before. But what my takeaway from that is that at the point when we are confident that something has been defeased or will be defeased, the SEC spent a lot of time, and both if you look at the 2010 release and in the settlement orders, saying how important notices of defeasance are to the secondary market. And that's something that also flows through many of the settlement orders, is the secondary market to them. I think the SEC understands that they are, I wouldn't say an advocate, but they're to protect the integrity of the secondary market. And so filings of redemptions, filings of notices of defeasance, and while this is not in the SEC, I can extrapolate, there have been a lot more investor calls to issuers lately saying, well, thanks, you filed the escrow agreement, but we need to have the verification report. If the verification report doesn't have the actual securities, we need to know what securities, because, and someone in the audience may know the answer to this, but clearly there's certain securities that they're able to book defease bonds in a certain way, but if they're secured with other securities, they have to treat them differently. So the level of disclosure on defeasances has increased dramatically.
I think a couple things to note with that. The Ascension order specifically says that one of the outcomes of the non-disclosure was that an outstanding principal amount of $24.5 million of bonds traded with a lack of clarity in the information as to the credit status of those bonds for up to a 2-year period. Nowhere in the original adopting release or subsequent releases up to the 2010 release is there any discussion of what the Commission means by defeasance, as Barron indicated earlier. There's some language in the 2010 adopting release that indicates that they may be talking about the moment when the decision is made to defease rather than the technical defeasance occurs. But what's really needed is clear interpretation from the Commission. If you look online and look at what Ascension Health has done since then, you see that their filings are all anticipatory. That the minute a decision is made to do a defeasance, not actually carry it out, they start filing conditional filings saying we have decided that we may, it's our intention to defease, but that may not occur. Similar language can occur in other securities filings such as tender offers, other things like that depend on conditions. But here's one where interpretation, additional interpretation is necessary, and probably caution is the byword of the day.
Yeah, I think how the state law interprets it. Many of us deal with bond orders, et cetera, that delegate certain authority to different individuals. Well, I don't think the mere delegation of authority to defeasance is a defeasance, but upon pricing and making a plan of finance, at that point you might, and there's oftentimes a lot of time between pricing and closing. You might think that you might want to get your notice of defeasance done prior to closing in that particular case, but that's something that we're reviewing as we go forward.
One footnote in this general area, a long time ago, the Commission brought what I believe may still be the only insider trading action in the municipal bond market. That involved an issuer in Kentucky, an issuer official, who, after the authority had decided to advance refund certain bonds, purchased some bonds for his own and for family members out in the open market before the word got out that those bonds were going to be advance refunded. And their credit rating and value in the marketplace changed accordingly. So the SEC clearly has that image in its historical mind and memory of the opportunity to exploit the knowledge that bonds may be advance refunded.
Yeah, one other thing that I thought was interesting, and there are 71 of these, so there's a lot of interesting things, but failure to file interim financial data. So we all think about it as annual financial data, but if your undertaking commits to that you'll provide quarterly reports, in this case the SEC said that failure to file those quarterly reports, even since you put it in your undertaking, was also a violation. So they looked closely at the notion that it was a contract, and if you violated the contract, that was something that they took account, even if they were available on the issuer's website.
Yeah, another thing, this goes back to Paul's point earlier about other documents that are part of the offering documents, is the fact that there was a private placement situation where there was a statement as to their prior compliance with 15C212, even though this was a particular issue that was exempt from 15C212, where there was a misstatement and there was a settlement related to that as well.
Right, private placements still are under the anti-fraud provisions of the securities laws. It's a purchase and sale of a security. The placement exemption keeps it either from requiring a 15C212 undertaking, or in the corporate world having to register with the SEC. But the anti-fraud provisions still apply because it's a security.
Yeah, so I caution everybody to keep that in mind as they're looking at transactions as well. I thought that was a very interesting settlement to end up in this group of settlements. So Paul, as we look back at these aggressive enforcement actions, MCDC, what we're learning, how can we tie a bow on the best way issuers can respond to these actions?
Well, in order to succeed in an enforcement action against an individual or an issuer, or any party to a municipal securities transaction, municipal advisor, underwriter, or any other party that they may decide to try to get a hook on, the SEC has to be able to demonstrate negligence along with material misstatement. And one way to refute negligence is to have a set of procedures in place that are followed that capture a standard of care that a reasonable person would exercise in pursuit of their affairs. So you hear a lot about disclosure controls and procedures. They, in my view, provide in effect an insurance policy to an issuer and issuer officials if they are tailored to what the issuer actually does, and they're followed. Because if they're followed, then the issuer and the officials are behaving in ways that a prudent person would behave in conducting their affairs, and there goes the negligence cause of action. The SEC is shut out. I think the SEC has moved the matter of enforcement of their laws and regulations away from the theoretical to almost the inevitable. And it's a question really of acting in a way that avoids it, even if the belief is that, ultimately we'll be able to prove a case. The cost of defense, particularly for a municipal issuer, can be astonishing. The way the process works is that a request for information arrives either by email or in the mail or both, followed by a phone call telling the issuer to freeze all documents. Don't destroy any more emails. Stop your automatic cleansing mechanism on your servers, and don't throw any documents out. And produce all documents to us voluntarily. Or if you don't, we'll be happy to go get a formal investigative authority and issue a subpoena. The cost of just capturing those documents and producing and just preparing them for production can easily hit $10,000. The cost of reviewing those documents before giving them to the SEC to make sure they're relevant, to make sure that attorney-client privilege communications are removed, easily adds another $20,000 or $30,000 to the process. That's before the attorneys even start interviewing people involved in the transaction to understand what the government might be looking for, misunderstand, and what's needed to set them straight and clear up any misunderstanding. Beyond that, when people come in and are asked to provide testimony, and the SEC has been very thorough in the last few years, following Chairman White's prescription. Just about anyone involved in an offering document at an issuer who is on a distribution list is likely to be called in to testify under oath before the commission. There are all sorts of costs involved in preparing that witness and defending that witness in the on-the-record testimony. And it continues from that place forward. So having procedures, having measures that will keep you from engaging in questionable activity that will draw the SEC's attention can be a very, very healthy investment.